Good afternoon, sir. I can hear you.
Okay.
Good afternoon, sir. Yeah.
Good afternoon. Okay, as Prof said, we are talking about technological innovations or use of ICT in legislative drafting. And if you recall that class, we discussed 8 principles of research when you are using ICT to conduct a research. While we are doing revision, I would want to make the class interactive. It provides us opportunity to get a feedback on how much you have learned. So I would want us to discuss just by volunteering. You tell us what you know about the topic we are discussing. Then, where you cannot explain further, then we come in. That way, you are also gauging your own level of understanding so far, so that you'll be able to, we want tomorrow, next tomorrow, maybe by next batch, one of you here should also be coordinating the class by reason of having gained sufficient knowledge to pass on to another, because that's the only way you retain it. If you leave it at theoretical level, just come here, go, you will become stagnant. You will become like a pool. The water is not flowing out, so clean one is not coming in. You are just there. You become like a lake, rather, not a pool. Become like a lake. The water just flows in and is there, and you are just accumulating information. You are not giving out. Fresh one is not coming in. You are not testing what you have. So, having said that, I would like us to look at the 8 principles of research when you are using ICT in legislative drafting. So, who can help us with one? Not necessarily in a chronological order, but that would be most appreciated if it happens. So, can we have volunteers? Can we have volunteers? Or I'll mention the principle, you tell us your understanding of it. This is a revision class, except a few people who joined much later. A good number of us here were in class when we treated these topics. So we have the principle of authority. That is the first thing you consider when you are using ICT. So what does the principle of authority say? Who can remind us? The principle of authority. I'll be forced to call him. So what is principle of authority all about when you are using ICT in your legislative drafting? Authority. Okay, thank you, Mr. Oscar, for coming to the rescue. Tell us, sir. Good. Yes. Okay. 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 Beautiful. Beautiful. So the principle of authority in essence states that when you are using a material, ensure or firstly ascertain that the material was published by the right authority, that the material you are relying on came from the right source, or was published by the right authority or government agency saddled with the responsibility to do that. So if you are relying on a law, ensure that it is a gazetted copy that is coming from the office of the Attorney General. Why is that important? If you are searching online and you click and you just put in the acts you're looking for, in some cases you will see the bill. So in that case, when you are searching, you either check from the website of the Attorney General of the Federation, that's the Ministry of Justice office, then check if they have index of laws. If it is not there, you look for any authorized agency. For now in Nigeria, there's an NGO called PLAC, P-L-A-C, PLAC. Somehow they have over the years been consistent in producing gazetted copies of our laws, or uploading gazetted copies of our laws on the internet. So if any document, any law you are downloading from PLAT's websites on their platform is a gazetted copy. Because I think they also provide consultancy service to the National Assembly. I wouldn't know the arrangements, but PLAC over the years have a good number of our gazetted laws. Anyone they are posting on their websites, they always have, is always a gazetted copy. Now, you might just see, people might just put anything out there and you go and download it, relying on it, not knowing that the information put up there is self-serving. We cited example when the Disability Act was about to be passed, and a research was made to see if Nigeria has had any law on disability. And the researchers stumbled on a decree on disability, only upon further investigation to realize that the military government never passed such decree. But some unscrupulous individuals hosted that document online and used it to collect money from donor agencies as if they are working on that thematic area. So the internet is just one vast place that you can stumble on anything. So it is important as a researcher that the documents you are relying on emanated from the right source, the right authority. If you are relying on data on education, UNICEF website becomes helpful. Any data emanating from UNICEF on education, particularly primary education, it will go a long way to be an authoritative source. If you are relying on data in terms of unemployment, our National Bureau of Statistics is there. You look up documents emanating from them because that is the right source to produce data for Nigeria or statistical data for Nigeria on subject matters. So, but if you now stumble upon an article written by one NGO, you should know that the NGOs don't have their own opinion. They don't have, we still talk about objectivity. They don't have their own objective opinion. Whatever they are writing or posting is usually colored by the opinion of the donors, of their funders. So it's that they usually write. It is what their project fund, what that fund is meant for, that is what they will support in their article. So you now see that the chances of manipulating figures to achieve a particular end, the probability is high. So that is it on authority. Two things: the document must emanate from the right source. The information you are getting must be from somebody that is an authority figure. Then if you authorize to make such information available, then if you want to talk about laws, the hierarchy, you look at our constitution first as the ground norm. So anything you are relying on, you must test it against the constitution. If it passes that test of uh, inconsistency with the constitution, if it passes that test, that it of consistency, that it is consistent with the constitution, then you are good to go. If it is not consistent with any provision of the constitution, you dump it, because the constitution is the highest authority. Then you come to case law. Cases emanating from the Supreme Court is the highest authority. So if you are researching and you stumble on a case, let's say the case, court of first instance, find out whether the case went on appeal. If it is on appeal, has the court of appeal delivered its judgment? Is it a final judgment? Was it further appealed before the Supreme Court? So if you confirm that the matter is pending before the Supreme Court and judgment has not been delivered, you might be a little wary, or as you're stating, you might state that as at now, this is the position of the Court of Appeal on this matter. However, it is pending before the Supreme Court and we will await the final determination of the suit. So that way you exonerate yourself from putting out false information, because if it eventually comes out and the Supreme Court rules otherwise, then sometime you might come out as having not done a thorough job. So that is it on authority. Next, please. Which other principle? That's it on the principle of authority. Okay, just permit me, let me get my tripod so that I can put this standing and my hands could be free. Thank you. So we are done with the first one, principle of authority. So what is the next one, please? We have done authority. Yes, next. Yes, Letati, you have the floor.
The next one is objectivity.
Objectivity, tell us about it, sir.
We said the information should be objective. It should be based on facts,
Okay.
and it should not be subjective.
Okay. So can you differentiate objectivity from subjectivity? Let us understand, sir.
An objective view of the facts, in fact, objectivity is based on the facts. It covers what is objective in respect of the whole subject that is to be considered. But a subjective is quite narrow, and it depends on the opinions of those who have added their opinions. So the difference is that objectivity is based on the facts and not on the opinions of those who are opining about the subject in issue.
Yes. Objectivity is not self-serving. Objectivity does not want to achieve a preconceived end. It does not paint the opinion of a few people or a segment or a political party or an ethnic group or a pressure group. Objectivity puts into consideration the whole fact and states it as it is without intending to achieve a preconceived end. Objectivity does not serve the interest of a particular group, whether minority or majority. But when it is subjective, it projects the interest of a particular group. It projects the the opinions of a particular group, it pushes to arrive at a preconceived, a predetermined conclusion. Okay, this is the picture we want to paint. When people finish reading, this is what we want them to understand or to have in mind. Objectivity, on the other hand, puts the facts before you the way it is and allows you to make your own conclusion. You draw your conclusion or whatever you make out of the facts. But subjectivity wants to guide your conclusion for every reader to come to the same conclusion as preconceived by the authors. So in doing research with ICT, you are required to rely on documents or materials that are objective, that does not project a particular outcome from the material. So that is very key. And how do you know some subjective materials? Look at the source also. I did tell us a while ago, if you are reading a material from an NGO, be wary about it, because they will be subtly pushing the position of their funder on that subject matter, regardless of what it is. If their funder is in favor of the subject matter, that is what you will read. If their funder is against the subject matter, that is also what you will read. So in doing your research, you rely more on materials that are objective. Thank you, Lesasi. So we've done two. We have 6 more to go. What's the third one, please? The third one. We've done objectivity. Next. Okay, thank you, Madam Joyce. You have the floor.
Yes, we talked about reliability as well.
Beautiful.
The
So tell us about it.
Yes, we said the material must be reliable, trustworthy, and we said traces back to authority, the authority that posted the material online.
One. How else do we confirm reliability?
We confirm reliability by looking at the authority that that posted the material.
Yes, we confirm reliability by looking at the authority that posted the material. Then we also look at their websites. Reliability, organization, and security are somehow connected. If it is hosted on a site that is not secured, we said you look at the HTTPS, then colon before slash. So if that S is not there, the S represents security, that this platform is a secure platform. If it is not there, then it is not reliable. Not only that it is not secured, it is also not reliable. Then you also look at the organization of that site, how they organized the material. Is there a sense of order, or there is total disorder? Even the arrangement of their material, is it alphabetically? Even if they are arranging their laws, are they arranging alphabetically? Are they arranging in the according to the year each act was passed? There must be a sense of orderliness there. But where everything is just there, then it is not the same. You do not have to rely on it. So it becomes a red flag. You take the material with a pinch of salt. So you consume such material, you may not, you don't rely on it. Next, we have done 3, or by extension 5. Next, We have done authority. We have done objectivity. We have done reliability, even though I mentioned two in passing. So next, we are wasting time on this. I thought we would have finished this by now. Oscar, you have spoken before, sir. Madam Hannah.
Okay. Good afternoon, sir.
Good
So
afternoon.
the next one we talked about coverage.
Coverage. Tell us about it.
Yeah, so for coverage, it means that the material being sourced, does it really cover the subject area of what is being legislated on? So are there judicial decisions that has been passed before? Are there new laws that have been passed? So that is what all the restricted areas that the subject matter is not meant to cover. So that is what the coverage actually talks about. It seeks to,
Okay. The
hello, sir?
coverage talks about the scope
Yes, the scope
of the
of
material you are looking at.
yes, sir.
Does it also cover what you are working on? So if you are receiving instruction, okay, your hand is still up. Yes, Hannah, you may proceed. Hannah, you raised your hand again. Okay, so as you're receiving your instruction, you would have by this training now understand that there are scopes, there are different jurisdictions of application when it comes to law. So when you are receiving your instruction, the person briefing you to an extent determines the scope of the work you're doing, and that is what will determine your coverage. If you are being briefed by a councillor in a local government area, you know that he has no power to make laws for the state or even the federal. So you are working on a bylaw, subsidiary legislation. Now, if you are being briefed by a state House of Assembly member, you already know that you are working on the law of a state. It does not extend to federal. Now, if you are being briefed by a federal legislator, that does not automatically mean that what you are working on will apply nationwide. Because I told us last time that the federal legislator makes law for the FCT. So that is where you now have to determine this brief I am getting, does it apply solely for FCT or does it apply throughout the federation? That is one. So if you are researching on materials, you should now check whether this material I'm consulting, does it cover the scope of what I'm working on? Does it have a limited scope? Some laws have limited application, limited scope. So this one I'm working on, does it have a limited scope? Does it cover what I am working on? So that is where the principle of anyone that has not been mentioned. Anyone that has not been mentioned. Okay, Mr. Seaman, I didn't want to call you, but you volunteered because I don't think you had joined the class when we treated this, but go ahead, sir. You have the floor, Mr. Seaman. Please, you may have to speak up a little.
Sorry, it's a mistake, sir.
Sir?
The mistake, sir.
Uh-oh. Please, can anyone hear him? I can't hear you. You can type it on the in-call messages. I can't hear you, sir. If anybody can hear him, let the person help me amplify what he's saying. Hello, Mr. Seaman. You can type your response, please. I can't hear you.
Okay.
Ebenezer, I've given you the hosting rights. I want to leave this session because I'm on another session.
Okay, Prof. Okay, sir. Okay, sir.
I was actually reading my also research.
Okay, so did anybody hear what Mr. Seaman said? Okay, while we wait for him, can we have another person? We have taken 4 principles, remaining 4. We have taken authority. We have taken reliability. We have taken coverage. It's remaining 1. We have taken 4. We have done authority. We have done objectivity. We have done reliability. We have done coverage. So it's remaining 4. Yes, Mr. Emmanuel.
Please, my own, it is questions that I want to ask, sir.
Yes.
Please, can I go
Proceed,
ahead
sir.
with the
Go ahead.
question? Okay,
Go
sir.
ahead, sir.
Thank you. All right, sir. Thank you, sir. So, please, what I want to ask is that in this legislative drafting, you have touched various aspects of the uh, proposing law, and as well as drafting, and as well as amendment, all stuff, all such of that. I want to ask that, is there a situation in the legislative drafting of which there should be total cancellation of a particular law, of which national on the based on national necessities, that the such law is going to be abolished completely? It's not even in terms of amendment this time around. Total abolished and cancellation. Is there a provision for that, sir? Thank you, sir.
Yes, there is. We also treated it. It is called repeal. If you ever heard us use the word repeal, it means total cancellation of an existing law. If they say this law is hereby repealed, it means this law is hereby cancelled. Do you understand? Yes. So
Yes, sir.
in
Yes, sir.
the
Thank you very
in the
much.
course of amendments, you repeal. The rule is this: if your amendment is having if you, let's assume you have an act that has 30 sessions or 50 sessions, and you want to amend it, out of the 50 you have flagged 30 sessions for amendments. What you do, instead of amending 30 out of 50 sessions, you repeal that law and do a fresh law. That is how it is done. If the amendment is too many, that it affects a large portion of the existing law, you repeal it. So, but if the amendment is just few sessions, you amend the main law and then do consequential amendments on other laws that are affected. But if the amendments are the sessions to be amended are too many, you do outright repeal of the law. So that is the process, sir. Does that answer your question? Hello, Mr. Emmanuel. Hello, Mr. Emmanuel, Mr. Julo. Does that answer your question? Hello? The person that asked question, can you hear me? Okay. I take it that he has a network challenge. Okay, so let's make progress. We have 4 more principles to to look at. So who can remind us? We've done, okay, Mr. Oscar, sir. Yes, yes, yes. Okay, security is there.
Sorry for the network, sir. I was hearing you clearly, but couldn't on my
Respond.
microphone. So I heard it very clearly. Thank you very much, sir.
You're welcome. So, Oscar, please continue. Yes, 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 yes. In fact, that one has to be an unconscious part of you. As you are logging into a site, is what you first of all check before you even proceed to looking at what things they have. So you first of all check that. Next, three more to go. We have done objectivity, we have done authority, we have done coverage, we have done reliability, we have now done security. So another one is currency. Currency. So the research you are making, the material you are relying on, is it the current position of events or affair of the law? So currency, is it the current position of the law on the subject matter? Let's assume you are doing a research and the National Assembly has given, or sorry, the High Court has made a pronouncement, the Court of Appeal has made a pronouncement, the Supreme Court has made a pronouncement. Out of these three, that of the Supreme Court, much as it is the authority, it is also the current position. That is one. Two, our constitution has been amended 5 times, or rather has been altered 5 times. That's the technical word actually for constitution. You don't amend the constitution, you alter the constitution. So our constitution has been altered 5 times, and a sixth alteration is ongoing. So assuming you bought the constitution at the third amendment or third alteration, and that is what you have, you are not aware that there has been fourth and fifth alteration. If you are citing, unfortunately, the provision you are current, even though it is from the constitution, it's just that what you have is not the current version of the constitution. So before you put out any documents, you must ensure that what the information you have gathered is the current position of the law on that subject matter. Even when you are advising, ensure that it is the current position of the law. I usually cite this example in FCT here. We have the Recovery of Premises Act 2015. That is the law that regulates landlord and tenancy matters in terms of recovery. And under that law, sorry, I have a call coming in. Just a moment, please. Let me take this. I was saying currency, that the example I usually give is our Recovery of Premises Act. One of the cardinal rules is serving of statutory notices. Before you evict a tenant, you serve him notice, depending on the nature of his tenancy. If it's a 1 year tenant, if it's a yearly tenant, you serve him 6 months notice. If it's a weekly tenant, it's entitled to 1 week, 7 days. If it's a monthly tenant, you also serve him 1 month notice. However, if he's a tenant at will, you serve him 7 days notice. That is our law, our written law. And over the years, people go to courts and they fail to get judgments based on irregular or invalid notice, meaning you were supposed to serve somebody 7 days notice, or after serving the first notice, you now serve the person 7 days notice of owner's intention to recover possession. So assuming you have served, if you fail to serve any of these 2 statutory notices, there are 2, the notice to quit and the notice of owner's intention to recover possession. Prior to this time, if you didn't serve any of these notices, what the court will do is that they will deny you judgment as a landlord and tell you that your notice was invalid. You did not comply with statutory notices. However, in 2021, the Supreme Court gave a judgment in Pillar's case. In that case, the Supreme Court now said that once a landlord serves you a plaint, whether he has served you notice before or not, once he carry court plaint and serve you, I am taking you to court to evict you from my house. The Supreme Court now says, once you have been served that plaint or summons, you are now sufficiently informed that landlord needs his house. So you as a tenant cannot come and say, the landlord has not complied with statutory notice. So indirectly, even though that was not the intention, indirectly that judgment has done away with, or I wouldn't say done away with the legal provision of statutory notice, but you can no longer rely on invalid notice as a ground to throw away a case in court. You can no longer rely on invalid notice as a ground to throw away a case in court. So today now, if in fact I have used that case, there's a case we did and they were saying our notice was invalid. All we did was to rely on the authority in Pillar's case to say, no, this is what the Supreme Court said. So why did I tell this story? That is the current position of the law. So if you were to advise and you are still relying on strictly, you must serve statutory notice, 7 days notice to quit, to be followed by 7 days owner's intention to recover possession, failure of which your case will be thrown out. That is a good legal advice or legal opinion, but it's not the current position of the law. So when you state that position, you can now say, however, the Supreme Court in Pillar's case held that once a defendant or a tenant has been served with a plaint or summons by the landlord, it is sufficient notice to the tenant that the landlord wants to repossess his property. Full stop. At that point, you have brought in currency. So in your research, you must check. When I did say, if we are to amend the Recovery of Premises Act now as it is applicable in FCT, certainly that position will be incorporated because it's a Supreme Court authority and it is the law now. Even though it is different from what the act says. So you know the school of thought that the law is what the court says it is. The National Assembly legislature can make their own law. It is what the judiciary has interpreted the law to be that is the law. So you now see the importance of currency, that while you are doing your research, you must ensure that whatever you are putting out is the current position of the law. So in researching, you check the statutory law and also compare it with case law. Which one is more current? That is the position of the law. So we have two more to go. Two more to go. We have done authority. We have done objectivity. We have done coverage. We have done reliability. We have done security. And we have done currency. So two more to go. Which other one? Which other one? Sorry, I've got another call, please. Not to push further, to rely on the material you are getting from that website. So we have mentioned 7. What is the last one? What is the last one? We have mentioned authority. We have mentioned objectivity. We have mentioned currency. We have mentioned coverage. We have mentioned reliability. We have mentioned organization, and we have mentioned security. What is the last one? What is the last one? What is the last one? There are 8 principles. So that is firstly what will help you. Anytime you come up, what will help you first is to know the number. There are 8 first. So if there are 8, if I mention 3 means that it's remaining 5. If I mention 6 means it's remaining 2. If I mention 4 means it's remaining 4. So, yes, Mr. Lesasi.
I think the last one would be accuracy, unless if it was discussed and
Accuracy. That's actually number 2. If you want to arrange them in alphabetical order, that's actually number 2. If you want, yes, if you are not alphabetical order, if you want to arrange them chronologically, the way it follows, that's actually number 2. So, accuracy. Tell us about accuracy, sir.
We had said that when we undertake our research, we should not compromise accuracy. We should make sure that we are 100% accurate on what we are working on.
Yes. Now, accuracy is very important. You must, these 8 principles, somehow, some of them checkmate the other. The fact that something proceeded from an authority doesn't necessarily mean it must be accurate as at the time it was released. Ordinarily, it should be accurate. ordinarily on the face value, that this thing came from this office means this is accurate. You should go and sleep that this thing is coming from this office. But we have had situations where the same executive is giving two contradicting positions on the same subject matter. So what it calls for is double checking. If this comes from this office, check it again to ensure that the one you are taking out is the accurate position. If you look at any material and you have confirmed authority, next thing you need to do is to confirm accuracy. Once you have confirmed accuracy, next thing you need to do is to confirm objectivity, still on the same material. When you have confirmed objectivity, next thing you need to do is to confirm coverage. When you confirm coverage, next thing you need to do is to confirm currency. You confirm currency, you confirm reliability, you confirm objectivity, or you confirm organization rather, then you confirm security. Once you have done these 8 on the same document, you can proceed with it. Another thing we will quickly discuss, we have overshot our time by 15 minutes, but we will just look at the current position of drafting, the current style of drafting. You know our history and where we are coming from. So I will just introduce, you already know it. Basically, plain language legislation or legislative drafting. 1. 2, gender neutrality in legislative drafting. We already know what plain language is. Doing away with all those legal jargon and Latin maxims, and also economy of word, reducing verbosity.